Hello, everybody. Hello, Nana Laura. Hello, Spider-Man. Oh, it looks like it's just the two of you. Which is all right. I don't feel so hot tonight. So it's not going to be a really long one. But we've watched this guy for a minute now. This is the dude that flooded his jail cell not once, but twice. The first time he kicked a pipe off, and the second time he stuffed it full of toilet paper to plug it up. He did thousands of dollars in damage to the offices below the jail. Oh yeah, you remember him now? Yeah, his name is Stephen DeLuna. And I've got an FTC going for him. And now we'll get to add his sentencing to it. Hello, Eileen Garland. Hello, Mark Ott. Thank you. It's been creeping up on me and I've been ignoring it. And I've taken the vitamin C, as Nana Laura is going to tell me in about 2 seconds. And I've been ignoring it. I've been taking Dayquil. And tonight it hit hard today. And I've been using my inhalers. Yeah, it's just it's not great. So I'll get through it. I definitely will. Hi, Ava. And I'm sure, the pet hair does not help me, but the love does. Tonight I went with if it ain't on a t-shirt, it's not real. My best friend's psychosis t-shirt. Oh, Bandit's trying to block Ava. Bandit, you are so funny. What's a URI? Upper respiratory infection. The only one that I could think of had a T in the middle. And I'm like, it's definitely not that. Yep, you get both of them. Yeah, I brought Bandit in here. Oh, hello, Army Brat 1964 love. Yeah, I don't know what it is, but it needs to go away and like now. It's like, I had sinuses the other day. My mom always called it rain face, where your sinuses get all yucky and it always happens when it rains outside. And I had that the other day because it was raining the day that I went and worked on my parents' yard. And so I just assumed that was that. And then that went into like the draining in the throat and then yeah, yucky stuff. So anyways, I'm gonna get the sentencing put on and go off camera and cough my head off. So yeah, that's gonna be the night.
Case numbers 24 CR 167, 24 CR 119, 25 CR 1, and 24 CR 221. Jill Gillette appears as Greenwood County Attorney. Richard Paw as Defense Counsel. Defendant Lopez de Luna appears at the Greenwood County Jail's Zoom location. These matters come before the court at this time for sentencing. Counsel, before the court goes any further, are there any unresolved issues of restitution existing in any of these four cases?
Judge, I represent Mr. Lopez de Luna on 24 CR 119 and 24 CR 167. I believe the restitution amount was for the that I am dealing with is 24 CR 167. There was a spreadsheet. It was a damage report from the Greenwood County Jail. Mr. de Luna does not have an objection to that.
Okay.
And Judge, that total, it looks like to me, is $2,737.24 if you add up the three totals.
Do you agree with that figure, Ms. Gillette?
I do, Your Honor.
All right, $2,737.24 in case number 24 CR 167, correct?
Judge, I think that's 74 cents.
Oh.
I can't read my own writing.
273774.
Correct.
All right. Should I have another defense attorney on here, or Mr.
You should
Paul?
have Mr. Fabre on here, Your Honor.
Favre will be on in a few minutes, he just stated in an email.
Well, isn't he the one that wanted these cases consolidated for sentencing before one judge?
That
Yes,
is
you are
correct.
correct.
Then I would expect him to be on the meeting on time. All right, it would appear, counsel, much to the regret of the court, that we're going to be at a standstill until our other defense attorney can join this meeting and we can conclude our business. Because I intend to try to make this as concise and efficient as possible, and I need defense counsel on this meeting to do so. So stay with the meeting, folks. Hopefully we will resume soon.
Understood, Judge. Oh, hey, Judge,
Yes?
could you and I have a quick breakout room to talk about something else?
Mandy, you can set that up while we wait.
Thank you, Judge.
Okay, it's ready for you guys.
All right, Mr. Favre has now joined the meeting.
Yes.
Mandy, I want to make sure that we're recording and broadcasting before I go any further.
Yes, Judge.
All right. Once again, the court calls all of the State of Kansas versus Stefan Lopez de Luna cases 24 CR 221, 24 CR 167, 24 CR 119, 25 CR 1. It's the court's understanding that Mr. Paw represents the defendant in the 119 and 167 cases, Mr. Favre in 24 CR 221 and 25 CR 1. Is that correct, Mr. Favre?
That is accurate, Judge.
Very well. Again, these matters come before the court at this time for sentencing. In 24 CR 119, this defendant appeared on April 3, 2025 and pled no contest to unlawful possession of a controlled substance, methamphetamine. In case number 24 CR 167, the defendant appeared before the court on April 3, 2025, pled no contest to criminal damage to property. And that was a level 9 felony, criminal damage to property. In case number 25 CR1, this defendant appeared before the Honorable Chad Crum, apparently back on May 22nd. He pled no contest to aggravated battery, a severity level 7 person felony. And on May 22nd, the defendant also, before apparently Judge Crum, entered a no contest plea to count 2 theft, a class A non-person misdemeanor. Pre-sentence reports were ordered in all the felony cases. This court had originally established sentencing in Mr. Paw's cases for today. Presuming that the matters were ready to present to the court for sentencing today, this court agreed to sentence the defendant in the other two cases as well. But I need to ask Mr. Favre the same question that I asked Mr. Paw earlier. Are there any issues of restitution in either one of your two cases?
I think that there was a restitution order sent in by Miss Gillette, and I think, let me just find that real quick. Let's see.
Part of
I
the,
don't think,
part of the
I don't
plea,
think there's any outstanding restitution. Sorry, Joe, go ahead.
the agreed restitution for the aggravated battery was $736.99 for the medical bills.
You're breaking up a little bit. Is that $736.09?
99.
99. All right.
That's medical bills for Mr. Dixon that the taxpayers paid. The restitution for criminal damage, part of the plea agreement was all the restitution would go on 24 CR 167. There was a spreadsheet prepared by the county maintenance. It was $2,737.74.
All right. So there's no separate restitution in 24 CR 221?
Right, that was just a theft, Your Honor. There's no restitution on that one.
Well, the item was recovered.
Okay. Very well. According to the face sheet of the pre-sentence reports, in 24 CR 167, the criminal history score found by the officer is criminal history score C. Any objection to that by the state?
No, Your Honor.
Mr. Paw, any objection by the defense?
No, Your Honor.
In 24 CR 119, the criminal history score was also found to be criminal history score C. Any objection by the state on that case?
No, Your Honor.
By the defense?
No, Your Honor.
All right. Criminal history score C will be adopted by the court, and the court will adopt the criminal history as stated in both of those pre-sentence reports. In case number 25 CR1, the officer found the appropriate criminal history score to be F. Any objection by the state?
No, Your Honor.
By the defense?
No.
All right.
That seems like a heck of a difference from criminal score C to criminal score F. I don't know how they're so widely apart.
So the court finds that the criminal history score applicable to that sole case is criminal history score F, and court will adopt the criminal history in that report. Obviously, criminal history is not a direct issue in the misdemeanor case. Mr. Favre, do you know of any legal reason why sentence should not be pronounced in your client's cases here today?
I do not.
Mr. Paw, are you aware of any such legal reason?
No, Your Honor.
Ms. Gillette, are you aware of any such legal reason?
I am not, Your Honor.
Mr. Lopez de Luna, do you know of any legal reason or any other good reason why the court shouldn't proceed further with all of these sentencings here today?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been any motions that have been filed by a party that need to be addressed by the court at this stage. Mr. Favre, do you have any motions you need to pursue?
We do not.
Mr. Paw?
No, Your Honor.
Ms. Gillette?
No.
Very well. Are there any victims or members of a victim's family who desires to address the court in regards to any of these cases? The court finds no such persons present. This time, court will ask for recommendations from counsel regarding an appropriate sentence as to all of these cases. We'll start off with Jill Gillette on behalf of the state of Kansas.
Judge, I have my recommendations with the cases in numerical order. Is that preferred, or do you want to do one case?
That's fine, counsel.
This was a global resolution of all of Mr. Lopez de Luna's 5 cases, with one being dismissed and having plea different cases. In case 24 CR 119, he falls into a border box. He would have up to 20% good time credit. The state is recommending the standard term of 30 months as his underlying sentence. He has mandatory drug treatment for up to 18 months. Believe that Senate Bill 123 is appropriate for him to be doing. He does have a significant amount of time of jail credit. This is the case for which he originally came in to Greenwood County. And he has 330 days total. I wish there was a total line under jail credit over there. He has up to 12 months post-release supervision. He has scored out for community corrections. He needs to follow all the standard conditions of community corrections, including alcohol and drug testing, having his SASE, and following up on all of the recommendations set out in it. He needs to have his DNA submitted if it hasn't already been submitted, $400 KBI lab fee, court cost, DNA database fee, community corrections and correctional supervision fee, booking fee, and the Senate Bill 123 offender assessment and reimbursement. We'd ask the court to inquire pursuant to Robinson as to his bids, attorney fee, and application fee. He has all the cases currently pending in Greenwood County for the court to consider as to whether they should run concurrent or consecutive to each other. He has been in custody continually since August. He had prior jail credit, was out, and then ended up back in custody. The rest of the cases were all netted while he was in custody at the Greenwood County Jail. In case number 24 CR 167, that case is the criminal damage to property case. The defendant actually had 2 times that the jail was flooded due to his actions. The total amount of restitution has been previously announced, and what that restitution would be. It had required extensive repairs because the pipe was kicked out from under a lavatory on one of the instances. The other one, the facilities were plugged up with the water running. He would have from August 20th to today's date, 289 days. That does overlap with the prior case. So it is up to your honor as to whether or not those days count for both cases or just one. As to concurrent or consecutive, there is a severity, it is a severity level 9 non-person felony. We would recommend the standard box of 12 months, up to 20% good time credit. Under Senate Bill 123 plus, he also qualifies for the mandatory drug treatment in this case, with up to 18 months probation and 12 months post-release supervision. Same community corrections requirements, and to complete the Senate Bill 123 program, court cost. There would be 1 DNA fee that is assessed to the first case, community corrections and correctional supervision fees, booking fee on that case. And Judge, I note that they put the SASE and the Senate Bill 123 assessment and offender reimbursement on every case. I don't know if he shouldn't have just one that covers all the cases as something to consider. And also we'd ask pursuant to Robinson for the court to determine bids, attorney, and application fees. In 24 CR 221, which is the misdemeanor theft case, the item was recovered. It was a vape that belonged to one of the jailers that was taken out of the office. That case is a Class A misdemeanor. I would ask for the 12 months underlying, suspended for 12 months supervision. I believe that it's appropriate to have community corrections supervise that concurrent to the felony cases on that 12-month term. There would be court cost, booking fee, and we'd ask the court to determine whether or not there would be attorney's fees. And there's generally a $60 probation fee in misdemeanors. I will leave it up to the court as to whether you assess that or if you charge one probation fee. On case number 25 CR1, that case is the aggravated battery. That happened also within the jail with another inmate. I would recommend the standard term of 18 months underlying. It is a person felony with up to 20% good time credit. He again scored out for mandatory drug treatment with the Senate Bill 123 plus program. I believe he needs to complete his Senate Bill 123. He's already going to have it in the methamphetamine case, but he did score out for 24 months of community corrections with up to 12 months of post-release supervision. And again, he scored out for community corrections, asked that he follow all of the standard terms of community corrections. No contact with the victim. That's Curtis Dixon. Court cost. Again, one DNA database fee assigned. Correctional supervision fees and community corrections fees, booking and fingerprint fee, Senate Bill 123 assessment and offender reimbursement. Again, I'd leave that up to the court as to whether he have 3 of those or 1 of those, and ask the court to inquire pursuant to Robinson as to his biz attorneys and application fee. Those are the recommendations at this time. Again, the restitution on Mr. Dixon's medical care, he was also an inmate. It was negotiated down by the county from several $1,000s down to the $736.99. That was a big savings for the taxpayers, but we would ask that he reimburse the taxpayers of Greenwood County for that amount, as well as the restitution to the taxpayers for repairing the jail facility.
And while you're at it, how about just in general, becoming a productive member of society and not such a child about everything?
Anything else, Ms. Gillette?
I think that's all for now, Your Honor.
Mr. Paw, the court will address you and ask you for your recommendations regarding an appropriate sentence in the 2 cases that you represent this defendant.
Okay, thank you, Your Honor. Your Honor, I'm going to start with 24 CR 119. I know that is a border box case. I did not file a motion for border box findings because pursuant to the PSI, drug treatment was mandatory. And as is practice in this judicial district and everything else, mandatory drug treatment basically trumps the border box. I believe the standard number is appropriate. The probation duration is appropriate. I know he needs to go get his drug treatment, and he's got a lot of fines and fees and everything. Judge, I need to address attorney's fees on this case. I have approximately $600. Mr. Lopez de Luna has been incarcerated for quite a long time. I know that he hasn't worked during that time, so I'm sure he does not have the financial wherewithal to make that. So I would ask the court to make the appropriate State v. Robinson findings and any other costs and fees on 24 CR 167. We are not, as previously noted on the record, we are not objecting to the restitution amount that was previously announced. We would ask that he be sentenced to the standard number, follow the presumption of probation with those terms and conditions in the PSI for probation. Judge, I don't remember if Ms. Gillette requested that the cases themselves run concurrent or consecutive to each other. I would ask that these cases run concurrent to each other, but I would obviously leave that to the discretion of the court. On this case, 24 CR 167, I have approximately $450 in attorney's fees. And for the reasons previously announced, I would ask that the court make the requisite State v. Robinson findings and waive those fees. That being said, Judge, I think I have nothing further.
Thank you, Mr. Paw. Mr. Favre, your recommendations regarding an appropriate sentence in your two cases.
Yes, Judge. So in 25 CR 1, we are asking the court to follow the recommendations in the PSI, place Mr. DeLuna on Senate Bill 123 probation with up to 24 months in community corrections. Mr. Lopez DeLuna is mandatory for Senate Bill. He has, according to the face sheet, 160 days of jail credit. Now, he was also in custody on the other cases, so I'll let the court figure out how to split that up. We have no objection to the standard costs and probation recommendations listed in the PSI. I will note for the court, Mr. Lopez DeLuna has been in custody, as is noted previously, a very long time. We'd ask the court to consider waiving his fees pursuant to State v. Robinson. I suspect that my fees in both cases will be somewhere in the neighborhood of 500, it looks like right now, 500 each. And so I'm still working on the final total on that. In regards to his misdemeanor case, Judge, we'd ask the court to impose 12 months underlying, run that concurrent to his other felony cases, and place him. It would be probably court of services. We'd ask a court of community corrections could courtesy supervise that so he's not reporting to multiple people. And that's our recommendations today.
Very well, thank you, Mr. Favre. At this time, the court will address the defendant, Stefan Lopez DeLuna, personally and ask him if he has any statements that he wishes to make in mitigation of punishment regarding any of these cases or anything further that he would like to present to the court.
No, Your Honor. No.
Very well then. The court will pronounce sentence in these cases at this time. Court will begin with case number 2024 CR 119. Court hereby establishes count 1 as the base sentence in the case for the offense of possession of drugs, a severity level 5 drug non-person felony in which the defendant has a criminal history score of C, thus placing him in grid box 5, drug C. The court hereby sentences the defendant to the aggravated term of 32 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court imposes no fine on that particular case. Court does find that this is a mandatory case, as are all of the felony cases for Senate Bill 123 drug treatment. The court noting the high risk score on the risk needs assessment combined with the finding on the SASE that there's a high probability of a substance abuse disorder does make this mandatory in each of the felony cases for Senate Bill 123. The defendant is ordered to treatment as approved by his community corrections officer for a period of up to 18 months. The length of the community corrections program is up to 18 months in 24 CR 119. And as stated earlier, there's no fine on that individual count. However, court will be assessing $400 restitution to the KBI laboratory $193 docket fee, $200 DNA database fee, community corrections fee, probation fee, booking and fingerprint fee of $45, and $300 reimbursement to the Senate Bill 123 program. Turning to case number 2024 CR 167 for the offense of criminal damage to property, a severity level 9 non-drug, non-person felony, in which the defendant has a criminal history score of C, thus placing him in grid box 9C. The court hereby sentences the defendant to the aggravated term of 13 months in the custody of the Secretary of Corrections of the state of Kansas. On that sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed. As stated earlier, this is a case for mandatory Senate Bill 123 treatment and up to 18 months of community corrections probation. The court orders the defendant to pay, in that case, $193 docket fee, community corrections fee, probation fee, booking and fingerprint fee, $300 in restitution to the Senate Bill 123 program. And since the DNA database fee is imposed in 24 CR 119, there will not be a repeat of that particular order. Regarding case number 2025 CR1, establishes count 1 as the base sentence for the offense of aggravated battery, a severity level 7 non-drug person felony, in which the defendant has a criminal history score of F, thus placing him in grid box 7F. Court hereby sentences the defendant to the aggravated term of 19 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed. Court does impose a probation duration of 24 months in that case. This is a mandatory case for Senate Bill 123 treatment and its programming. Court orders payment in 25 CR1 of a felony docket fee, felony probation fee, community corrections fee, $45 booking fingerprint fee, $300 to the reimbursement to the Senate Bill 123 treatment program. Regarding these 3 felony cases, the court determines that the combination of this defendant's long-term incarceration and a lack of financial wherewithal otherwise, the court will waive bids assessments on all 3 cases. Turning to the misdemeanor case, case number 2024 CR 221, for the offense of theft, a Class A non-person misdemeanor, this court imposes 1 year in the Greenwood County Jail. Court notes that that is the equivalent of 365 days in a calendar year. Court orders Stefan Lopez de Luna to serve 365 days. No probation will be granted in that case. Court will assess, in this case, a misdemeanor docket fee. Following the service of what appears to be 35 more days, the court's going to order Mr. de Luna released on this case. I do wish to make clear that the court is granting community corrections probation on all 3 felony cases, but ordering the defendant to serve the remaining balance of his misdemeanor sentence before being released.
I know it sounds like he's kind of getting off easy since he's only being ordered to serve the 35 more days. But keep in mind, he's been in custody this whole time. We're talking, it's been months. So he's not really getting off easy.
The court will be granting concurrent jail time credit on all cases, as the court is running these concurrently with one another. Court is taking this into account in imposing the aggravated numbers on each one of the felony cases. And the court noting that there is still a considerable amount of prison time to be served if Stefan Lopez de Luna does not successfully complete Senate Bill 123 community corrections probation. Mr. Favre, how much are your fees on the misdemeanor case?
I think it'll be about $500 total when it's all said and done.
Thank you. Obviously, the court's imposed the docket fee in this case. Again, the court would have to make the same finding regarding his financial ability to pay. Any attorney fee reimbursement is waived by the court in the misdemeanor case. He's got plenty to pay off on all of his cases independently of that. I would ask Community Corrections, Mr. Clausing, to monitor the progress of anything he does owe in the misdemeanor case. I understand that his time's flattened. He won't be on probation with your office, but if you just keep an eye on that as part of his overall requirements as he's supervised by your office.
Yes, Your Honor.
Greatly appreciated. All right, the court has already dealt with the issue of jail time credit. Again, the court awards $330, 330 days of jail time credit that he's amassed on all of these cases. Since the court has run all of the cases concurrently, he's entitled to 330 days credit against all of the cases, including the misdemeanor case, and he's got 35 more days to do before he can be released on that one. He is placed on Community Corrections felony probation on the 3 felonies as of now. I want to make sure the record reflects that the court has ordered $736.99 restitution in case number 2025 CR1 and $2,737.74 restitution in case number 24 CR167. Now, if my notes are correct, counsel, those are the only 2 cases in which restitution orders were sought. Is that correct, Ms. Gillette?
It is, Your Honor.
All right. If you could have the respective sentencing journal entries so reflect.
Judge, are you ordering the booking fee on the misdemeanor case?
I am. That would be an additional $45. Thank you, Ms. Gillette. Now, this should have been handled earlier in the case. Is he registering as a result of the aggravated battery conviction?
No, Your Honor, it's not an aggravated battery with a deadly weapon. There's no registration requirement.
All right, very well. Do you agree with that, Ms. Gillette?
I believe so, Your Honor.
Again, that would have been a matter handled at time of plea ostensibly. All right. All right, Mr. Lopez de Luna, at some point in the future, you may have the right to seek expungement of one or more of these offenses. Certain statutory limitations do apply. You have any question about your right to seek Judge,
you're froze up. I'm not sure if you can hear us or not.
He should be back on in just a minute.
All right, addressing my assistant, Mandy, are we still recording and broadcasting?
Yes, we are, Judge.
And I trust I'm visible and everyone can hear.
Yes.
All right, apparently I had an internet service interruption on my end. Everyone else is still with the meeting, I trust?
Yes.
All right, thank you. The court was addressing, I believe, when I lost connection, that the defendant has a right to seek expungement of these offenses, though there are statutory limitations. And if he has any questions about that, he should address those questions to a lawyer. The court further advises the defendant that a criminal defendant in Kansas may have the right to appeal their convictions to an appellate court having jurisdiction. And if a defendant is unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal, and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, a defendant has 14 days after this judgment in court to file any notice of appeal with the clerk of the district court as to any of these cases. The defendant does have a right to appeal these sentences if the court has ruled adversely to him at this hearing. I will remind the defendant that there is prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentences are fully discharged. The court will be remanding the custody of Mr. Lopez de Luna back to the Greenwood County Jail to serve the remaining balance of the misdemeanor sentence that's been imposed here today, which the court computes at 35 more days before he's released on his probation on the felony cases with Community Corrections. Mandy, we have to move on. Mr. Clausing, I regret that we're not going to be able to keep this meeting open for a breakout session with Mr. Lopez de Luna, but do you have any verbal instructions that you would like to give him?
No, Your Honor, I might run down the hall to the jail and talk to him personally.
Excellent. Mr. Clausing, I appreciate that. All
Judge,
right.
are you
yes.
setting any monthly payment amount? Or just as directed by his ISO?
I don't have any information regarding his future employability or what his future income might be. I think the court's not inclined to do that. I would ask, however, after analysis of the defendant's financial circumstances, Mr. Clausing, that you establish one and have your client sign off on it.
Yes, Your Honor.
Have part of his sentence be that he has to do an unpaid internship with a plumbing company so he can see how difficult it is for the people that had to come into the jail and fix the stuff that he deliberately, intentionally broke. Plus, he would be learning a life skill. When he would get done with his unpaid internship, then he could actually get paid doing a skilled labor. And maybe if he had the means of doing some type of skilled labor, then he wouldn't be such a drain on the society.
Thank you. Anything else, Ms. Gillette?
I think that was the last note because we usually have to mention payment arrangements. So are you wanting the 35 days that he is spending in the Greenwood County Jail to also be a condition of his supervision so that he gets credit for it against his underlyings?
Well, all of his sentences run concurrently.
Right.
So by serving time on this one, he will be entitled to credit on the other cases as well.
Well, if I write it in the journal entry, then KDOC will have that there's 35 days he's serving as a condition of his probations.
Very well.
Okay.
I trust there's no objection to that by defense counsel.
No,
Mr. Favre?
no, Judge.
All right. And Mr. Paw?
No, Your Honor.
All right. Thank you. All right, Mr. Favre, I'll ask, is there anything else from your perspective that we need to address here?
No.
Mr. Paw, anything further?
No.
Very well then. Mr. Lopez de Luna, you have any questions about what we've done here today?
No, Your Honor.
All right. Mr. Lopez de Luna, just looking at these cases, you're darn lucky from this court's perspective that these are a mandatory Senate Bill 123 program cases, or you very well could be looking at a prison sentence here today, because you appear to this court to be a menace to society that should be locked up. Your attitude has to change. You have to follow rules and you have to follow the law, or you'll be back before this court facing further sanctions regarding all of these cases that you've been convicted in. I hope that you can be successful out there once you reach the community. If there's nothing further, the Lopez de Luna matters will currently be in recess, and this meeting may be
Ended for all. That's what, that's what he was going to say. Oh, yeah. Oh, hey. She was in here the other day, and I told her that you were looking for her, and she's just been dealing, a lot with her medical stuff, and she was really grateful that you had been asking about her and checking up on her. That meant a lot to her. So definitely keep her in your prayers. Hello, Grouchy Mama Bear. I would, but I can't shout right now. I can barely breathe right now. I'm gonna go for the night, you guys. I really do appreciate you guys coming out and hanging out with me. I know it wasn't super exciting, but we've been following him for so long. I just had to. I had to show it. Hello, Bandit. Everybody's favorite tortie. Everybody's favorite tortie. Yes, Mama's pretty girl. Thank you, guys. I definitely will. I have to use my BiPAP. I don't wanna. Like, do you know how obnoxious that's gonna be trying to use the BiPAP when I'm all congested? No, I don't wanna. Okay. How does that work? I have to be a total mouth breather for the night. I'm definitely going to have to add more water to the humidity tank. Thank you. This helped. I'm sure it did. I feel a little bit better than when I first, when I it wasn't that I wasn't looking forward to coming on. I was, but there's that part of me that was like, I'll just go back to bed. Oh, thank you so much, Cynthia S. Well, you kind of did sort of adopt me. You and C-Rex, you guys are my adoptive mamas. You guys took over when my mama passed away. So you have to listen to me when I get in my I'm sick, I'm whiny moods. That's your job. Okay, guys. All right. I love you. Be safe, be well, sleep sweet, and much love.